What's up, everybody? Welcome back. More updates on the Karen Read case. What's going on with these jurors? What did they say? What did they vote? And while this may look like a clickbaity title, this is actually the first time since the trial concluded in a mistrial that I thought the answer might actually be yes. We've got a bunch of documents to get through today. We're going to read what the Commonwealth said, how the defense responded, quotes from the defense after the Commonwealth's motion, and of course, we will answer your questions. So make sure you hit the like button and subscribe to our channel if you have not done so already. All right. So the first thing we're going to look through here is the Commonwealth's motion from, I think, last week. And this is the first indication we've gotten from them that jurors have reached out. And in this motion, they tell us that, in fact, jurors have reached out, what the jurors said, and how they responded or what follow-up they've done, if any. So first, the Commonwealth's post-trial notice of disclosure. Now comes the Commonwealth in the above captioned matter and provides notice regarding the defendant's post-trial claims regarding the jury's deliberations. On Sunday, July 21st, 2024, ADA Adam Talley received an unsolicited voicemail on his office phone line from an individual who identified theirself as a juror by full name and seat number. The individual stated, by the way, this was on July 22nd, and they didn't file this until August 1st, which I just find interesting, the timing. But what did they say? It is true what has come out recently about the jury being unanimous on charges 1 and 3. On Friday, July 26, 2024, ADA Adam Lally received another unsolicited voicemail on his office phone line. Shocker, ADAs aren't picking up the phone. That's just a side note and a side joke, but it's very hard to get a hold of them, especially if you're a criminal defense attorney on a case. Criminal defense attorneys, they either answered or called back or had communication. These are all just voicemails on his office phone line. And that individual stated, I can confirm unanimous on charges 1 and 3 as not guilty. And as of the last vote, 9-3 guilty on the manslaughter charges, on the lower level manslaughter charges. The Commonwealth did not respond to this individual, as the Commonwealth is ethically prohibited from engaging in discussions about the jury's deliberative process. So we learn a few things here. Number one, the Commonwealth now knows from jurors, which, by the way, they can pretty much confirm or deny if these are really the jurors based on their name and seat number and things like that. It'd be really hard for them to have that information at this point. Not with 100% certainty, but with at least have a pretty good idea if these jurors are legit or not. Now, one thing we don't know, are these the same jurors that have already reached out and spoken to the defense, or are these different jurors? My guess would be they are the same jurors that already reached out to and spoke to the defense. So maybe we're not getting any new information from the jurors, but we are getting new information, and that is as of July 21st, which is 2 weeks ago, the Commonwealth now, upon information and belief, has knowledge that counts 1 and 3 were not guilty. That, to me, is a huge revelation, because we didn't know. Were these people just, trying to talk to the defense, trying to help the defense, just talking to the defense? Maybe the Commonwealth doesn't know. Let's give them the benefit of the doubt. But for them now to have this knowledge, and then they didn't follow up. Why did they not follow up? Because they did not ethically believe they can talk about their deliberative process, which should be no surprise. That's exactly what they put in their motion, that we can't do a juror interview because it would look into their deliberative process. It would violate the province of the jury. And so they're going to use that same argument here as to why they didn't respond. That's the first argument, at least, as to why they didn't respond. So not a surprise, but they were given this information. And so let me just take a step back. And I've never been a part of a mistrial as a prosecutor, but as a criminal defense attorney, I have been. And as a civil plaintiff's attorney, I have been. And both times when it ended in a mistrial, we didn't retry it the second time. The civil case we were able to settle, which is, kind of like a plea agreement, but it has to do with money. We were able to settle. We did poll the jury in that case, so that helped a little bit. But everybody takes the information. All normal, rational lawyers, especially trial lawyers, who we always say, and you guys know, and you've heard some derogatory comments from lawyers about people at a bus stop and things like that. We know that we don't know what a jury's going to do. I'll repeat that. Lawyers, trial lawyers know that we don't know. Matter of factly, we do not know what jurors are going to do. So when you get some information, like a mistrial, even if you don't poll the jury, but if you get more information like this, which is almost like polling the jury, when you have a situation where you learn more information, you make decisions based on that information. And from my perspective, in the criminal case, we were defending the case. It was actually, I thought, a pretty good case for us. There was one really bad fact that my guess is some of the jurors couldn't get over. And at the end of the day, it ended. It was a week-long trial. They deliberated for like a day and a half, and it was a mistrial. And what did we do after that? I tried to talk to the prosecutor. It was difficult. I had to go kind of above her head, talk to the her supervisor. Then we had to even go kind of above his head, not above his head, but bring in the actual state attorney. We talked through this case. We talked through everything, and they ended up reducing the charges to a ticket, basically, and the case went away. They could have retried it. It was well within their legal right to retry it, but we got more information. And my discussion and arguments to the state attorney, to the supervisor, and to the assistant state attorney was, listen, you know this case is weak for you guys. You went, you tried it. That's your right to do. You didn't win. The jury could not convict unanimously of only 6 people here in Florida. This person is has a license that this would really hurt. So it kind of works for everybody. If we do something like this and she doesn't get away necessarily scot-free, she gets a ticket, she has to pay a fine, things like that. And at the end of the day, they ended up agreeing with that because I think they were seeking truth and justice. They believe she committed a crime. They couldn't prove it. They realized that after the first trial. Will this information be enough for Adam Lally and the DA's office and the Commonwealth to say they just cannot try counts 1 and 3 again? They can't prove them. They failed. They lost. And in the interest of justice, they should not and could not try it again. Now, count 2, for whatever you guys think, however you think the trial went, whatever anybody would have voted, they almost won that. They didn't, but they almost won that, and it's their legal right. And some would say they should, based on the fact that there's a victim, justice is being sought, and they convinced 9 out of 12 that she was guilty on manslaughter. So going forward on that, legally speaking and ethically speaking, at this point, I understand why they would do it. I said before the case I wouldn't, based on the evidence they had and the evidence that came out on the defense side. But on 1 and 3, it is coming to the point where I feel like they have to drop those charges. Will they? I don't know. But I feel like we have gotten to the point where they absolutely should drop those charges. Let's keep reading. Similarly, the Commonwealth received emails from 3 individuals. So that's 5, and I think that's how many the defense has. I don't know if the defense told them to reach out to the Commonwealth. Again, it could be 5 completely different jurors. It could be a combination of some that did talk to the defense, some that didn't talk to the defense. But they received 3 emails from individuals who indicated they wish to speak anonymously. Very different than the person that, just said their name on the phone call. They didn't mention the anonymity. On July 16th, so this is 5 days before the phone call and almost 3 weeks before today, the Commonwealth responded to the emails. Wait, on the 16th, they responded. So when did they get the emails? We'll just assume the 16th. The Commonwealth responded by saying the Commonwealth would welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiring as to the substance of your jury deliberations. Again, willing to talk, but not about what they don't want to talk about and the information they don't want to find, which to me is not seeking truth and justice. It's burying your head in the sand if you don't think you're going to like what you find. That would include, so this is what they don't want to discuss, that would include your individual or the jury's collective thought process, the content of your deliberations, or the reasons for your deliberations. Now, I agree, the reasons and maybe the content, but their ending vote does not invade the province of the jury. If it did, we would never know their vote at the end of any trial. It was further explained that the Commonwealth could not promise confidentiality. And I thought this was interesting too. So we know the defense said, we're filing these motions. We have these affidavits. We're going to, try to keep their names anonymous. We're just going to tell you, we confirmed they are jurors. The Commonwealth's like, we're not going to do that for you. We can't promise anything. Now, obviously that's true. Nobody can promise complete anonymity. These people were sitting in a public courtroom where there were other reporters and people and cameras in that same courtroom. Now, the cameras didn't film them, but tons of people saw them. People know who they are. Their names could get out. Their faces could get out. So nobody can promise them complete anonymity. But the Commonwealth's like, yeah. We're not even going to try. You want to be anonymous? Well, we can't help you with that. That's what it seems like to me. That would include your individual or the jury. Sorry. It was further explained the Commonwealth could not promise confidentiality in that the substance of any communications may necessitate disclosure to the defendant or the court. So they're basically warning them, be careful what you say. The public might find out about it. Seems to me like maybe trying to keep this stuff quiet. Now, maybe not. But to me, it seems like there's a way you could do this where they realize they wouldn't be reaching out to you. Let's be honest. Let's just back up for a second, right? My mind is getting twisted into a pretzel here with this reasoning. They're reaching out to you. They're telling you. They know you're going to have to share it with the defendant or the court. If they didn't want you to share it with the defendant or the court, why would they reach out to you just so that you could know as the prosecutor? That doesn't make any sense. Hey, just so you know, Lally. It's like, no, obviously they know the defendant and the court are going to find out about this, and that's why they're reaching out to you. All three jurors declined to further communicate with the Commonwealth and provided no information about the jury's purported votes. Shocker. When you tell them they can't tell you about the votes, when you tell them they can't tell you about the substance, when you tell them that you can't keep their name silent, and you basically tell them this might not be a very good idea if you want to remain anonymous and you keep talking to me, I might have to tell everybody what you're telling me. Then obviously it makes sense that they would not come forward. Now, let's take it on the flip side. And what's bad about this for Karen Read and good for the Commonwealth? This would make me think at least these three jurors would not be interested in a hearing, a juror interview. They wouldn't want to or willingly participate in something like this that would get the information out there. That's not good for Karen Read. If they go away and they're like, no, we don't want to have anything to do with this. We want to remain anonymous. We want to keep quiet. That's not good for Karen Read, because now if we're going to get some kind of juror interview, the court would have to force or compel their appearance, which they could. And again, I care about justice. I'm a big fan of justice. And if they voted not guilty, and it makes them uncomfortable, we need to get them out there to vote on it. It sucks. I hope it doesn't happen. But they were picked to be the jury. And we are where we are in this case. But it seems like the Commonwealth is giving them an out and they've taken it. Now, the Commonwealth didn't force them to decline. The Commonwealth didn't force them not to comment. The Commonwealth didn't force them not to say anything. They still could have after this email, and they chose not to. So next, let's take a look at a tweet here that from Ted Daniel, who's been following the case closely. We've gotten a lot of information from him. So after that, this was on August 2nd, the statement from Karen Read's attorney. This was after they filed that prior motion we just read. The Norfolk County District Attorney's Office, in its new filing, finally admits that they have received the same information that the defense has received from sitting jurors. Karen Read was acquitted on 2 charges, including the ultimate charge. So he's saying the same information. I don't know if that's an indication that it's the same exact jurors, or if he just means whoever the jurors were, they're saying the same things that the jurors spoke to us said. Most importantly, not guilty on 2 counts. And he continues, we now expect that the DA's office will do the right thing and dismiss at a minimum indictments 1 and 3. So counts 1 and 3. They expect it. Now, what does that actually mean? Almost nothing. The defense attorneys are going to try to use their leverage and use the media and use their platform and the microphones and the public to try and, push this is the right thing to do. They should do this. We expect them to do it now. I don't think they actually expect them to. Just like I don't expect them to, even though I think without a doubt, they absolutely should at this point. All right. And then, I'll read the last part. Thanks, Rebecca, for gifting some memberships, and Azam and Laddie, everybody gifting memberships. Make sure you have that turned on. Last paragraph. This is Yanetti speaking. Of course, our position remains that all 3 indictments should be dismissed because they have charged the wrong person. Should they persist in pursuing this wrongful prosecution, we stand ready to defend our innocent client no matter how long it takes. Once again, potentially a little bit of posturing there by Yanetti, but he's saying what he needs to say at this point. So before we read the defense's newest motion, I think that was filed today. Let me check the date on this. Yes, this was filed today. So brand new documents we're going to read here. But first, a couple questions. Azam, hey, Peter, what's up? Please tell us about the storm in your area. Hope there are no bad damages. Stay safe. So a ton of rain, some flooding. So we're dealing with that, but nothing catastrophic, nothing major again, thank God. But this was probably the worst one so far. And we didn't really do anything to prepare for it. Like we didn't even bring in our pool furniture. We didn't think it was going to be that big of a deal. It was just a tropical storm, but there was a ton of rain. David Reese, I think the Commonwealth only acknowledged the communication because the juror contacted a journalist. Ooh. See, now that's interesting. And if I'm the defense, I'm bringing that up to the judge. Judge, the 16th, the 21st, and we don't hear about it? Why didn't they come out and tell us right away like we did the next day? Were they trying to hide this? Were they going to act like they didn't know this information? I would ask those questions. I think those are important questions. Matthew Bradford, did the jury need to come back with a verdict on all counts? Or if they told the judge unanimous not guilty on 1 and 3 and be deadlocked on 2, could she have dismissed 1 and 3 and only declared a mistrial on 2? So yes, legally and technically, procedurally speaking, they could have voted not guilty on counts 1 and 2. Whether that was clear to them, seems like the answer to that is no, that it was not clear. But yes, technically they could have. Elizabeth, does this rise to the level of intimidation? No, not even close. Not even close. This is their legal position. They're stating it. To me, if anything, it's a wink, wink, like go away. It's not at all intimidation. It's not threatening. It's not forcing them to do anything. Marion K., lawyer, they need to bring the jury in to ask them these things individually. Why hasn't the judge done this already? Well, again, we're getting to a position now, and that's one of the bigger things in that motion we just read from the Commonwealth. These jurors don't want to do that. At least some of them don't want to do that. And that's going to give the judge an out potentially. That she's not going to compel these jurors who did their civic duty to come and say something on a whim because a couple jurors reached out. Less than half the jury reached out to the defense and said this. And even less than that actually want to show up to court to talk about it. It's going to give her an out. Although I would still order it. I would still compel them. Why? Why would I do that? Because it sucks and nobody wants to do this to jurors. In the interest of justice. I don't want to force any normal person to sit in court for 8 weeks and listen to a trial, right? I don't want to do that, but we have to do that. We have to do that for our justice system to work. And so while I wish it didn't have to be that way, that is what I would do if I was the judge. All right. Now let's get to the defense motion here. All right, Karen Reed's third supplemental memorandum in support of her motion to dismiss. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby respectfully submits this third supplemental memorandum in support of her motion to dismiss, filed July 8th, 2024. So it's been a month of putting motions out and supplementing them, etc. As reflected in the attached supplemental affidavit, of David R. Yanetti, a deliberating juror in this case, Juror B, placed an unsolicited phone call to Attorney Yanetti confirming the prior affidavit of David R. Yanetti accurately quoted his/her text messages saying it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. So what is this doing? I believe I read it a couple times because I was like, Juror B, we've already had a Juror B. This is one of the hearsay jurors that had a intermediary, whatever, somebody who was a connecting person from them to the defense, maybe even separated by 2 degrees, coming out and directly calling the defense saying, that's true. And this happened on, what day was it? I don't know. I'm assuming in the affidavit we'll figure out what day it is, but I think this was pretty recent. So this is now eliminating some of the hearsay problem. And I think this is 3 or 4 directly reaching out to the defense And would they show up in court? I don't know. Let's keep reading. Juror B clarified that he or she meant to write, no one thought she hit him on purpose or even knew that she had hit him. So again, that's pretty much what we thought happened. So nobody thought she hit him on purpose, or if she did hit him, nobody thought she even realized she hit him. But what it doesn't say is nobody thought she hit him. It seems like at least 9 people who voted guilty on manslaughter thought Karen Reed hit John O'Keefe with her car. So what does that say with a lot of us, myself included, that we're talking about the scratches don't make sense, the busted taillight doesn't make sense, these defense experts are so good, I don't think he got hit by a car. That's how I was feeling when I heard the evidence. The vast supermajority of the jurors did not agree, which to me makes me think the cover-up fell flat. The police smashing the taillight and planting the evidence fell flat. And even those great experts hired by a third-party agency, not the defense, those unbiased experts, and I put in quote because they made a bigger deal to us, but not to this jury. And I think, out there in the public and as far as the chat goes, more people were on the not guilty side than guilty side, but there was still a chunk of people on the guilty side that felt that way. There are lay people, average people, normal people that believed she hit him. And seemingly 9 of them were on that jury. Not just they believe she hit him, but believe the Commonwealth proved it. He believes that every member of the jury, if asked, will confirm that the jury reached not guilty verdicts on indictments 1 and 3. Based on the attached affidavit and all of the reasons set forth in its ongoing motion, first and second supplemental memo, the defense respectfully renews its contention that the jury acquitted Ms. Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial as to those counts, and therefore the double jeopardy protections of the federal and state constitutions require that those counts not be retried. If the court for any reason would not credit the affidavits of counsel in the same manner as the court would credit identical affidavits from the juror in question, or an affidavit that the juror has reviewed counsel's affidavits and confirms the accuracy of the representations attributed to them, then the defense respectfully requests permission to initiate contact with jurors A, B, D, and E, again, leaving out C, who is the one with the intermediary, for the sole purpose of asking them to affirm the accuracy of the 3 affidavits of Alan Jackson and supplemental affidavit of David Yanetti. So what's interesting to me is maybe juror number C is not so friendly to them anymore. I don't know the answer, but maybe that's what's going on. And maybe that's why they're leaving juror C out of some of this stuff. All right, let me get to a couple more questions here. Unrelated topic, any chance of you analyzing the CoffeeZilla Logan Paul dispute and the issues Coffee is having with his legal defense insurance company? I don't know anything about that. I mean, I know who those 2 people are. If this is something you guys want me to look into, let me know in the comments. Autumn Blaze, lawyer, would the Commonwealth be doing the same as the defense here if the jury found her guilty on 1 and 3 and hung on 2? What is the precedent? Thank you and stay safe. So that's a good question. I mean, if they found her guilty on 1, then I think they would have given a verdict. I don't think they would have mistried it if they were guilty on 1 and not guilty on 2 or hung on 2 or anything like that, as even though they were separate charges. So it's hard for me to fathom, but I think yes, my guess would be they would try to, but again, it's harder because it's the defense's right and the defendant has, more rights than anybody else in a trial with their life and liberty on the line. But as a, process of just thinking about it, yes, I think they would try to do it. I don't think it would be successful from their end though. Didn't Bev instruct the jury to leave it blank for not guilty? No, I don't. I've listened to those instructions. I think they're confusing. I don't think she did it in the right way, but the jury still could have gone not guilty on 1 and 3. Or the jury couldn't disprove count 2. Well, that would mean they misunderstood the law if they were trying to disprove count 2. If you're going to vote guilty according to the law, 9 of them had to believe that she hit him with the car, and the Commonwealth proved it. Now, the other 3, we don't know. The other 3, you're right. They thought, or they could have thought maybe the Commonwealth didn't prove it. So they could have thought she still hit him with the car. I don't know what the other 3 that were voting not guilty thought. So not 100% positive on that one. Thank you, Anna Lee, for the super sticker. All right. So now let's jump into Yanetti's affidavit here. Whoops. Zoom in a little. All right, here we go. I, David Yanetti, do hereby depose and state that the following is true to the best of my knowledge and belief. Actually, I wanted to mention one other thing. Sorry, it popped in my head as I was reading this. What Yanetti was asking for in the last motion, as far as like take the affidavits as if it's the juror's words, he's saying, Judge, I'm an officer of the court. I'm swearing to you. If you can believe me and trust me, take these as if they're true from the jurors and make your decision based off that. Because there are certain things you have to do where you have to have evidence. You have to have record evidence. Affidavits are record evidence. So take it as record evidence. If you're not, let me know. Don't dismiss this motion or deny this motion because you don't consider this record evidence. If you need me to get something more or better, let me know. I'll reach out to them, because he doesn't want to reach out to them and do something wrong or unethical and then have that come back to bite him. So he's asking the court for guidance. He says, I have what you need, Judge. Tell me how you want me to do it. Either with these affidavits, which I think should suffice, but if you think no, let me know and I'll call these jurors up. Or let's just get them in the courtroom. All right, what does Yanetti have to say here? I am an attorney licensed in Massachusetts since September 20th of 1989. My main office address is 44 School Street, Suite 1000A, Boston, Mass. On January 29th, I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. So again, because I didn't know a lot of stuff that happened before this trial, he was retained the day it happened. That's interesting. On July 31st, okay, so he got this a couple days before he filed that motion. July 31st, I received an unsolicited phone call from someone who informed me that he or she was a juror at the trial of this matter. The caller informed me of his or her full name, which confirmed for me that he or she, Juror B's, information about whom I included in my previous affidavit filed in support of this motion. So this one is even a step further. It's confirming that who they thought Juror B was in the prior one is correct by the horse's mouth, by Juror B themselves. By the way, it's interesting. You'll notice through here, somehow the defense is able to file these motions, put in these affidavits, explain what the juror said, and keep their unanimity. So why could the Commonwealth not do the same? During my phone conversation with Juror B, he or she confirmed for me that the jury reached unanimous not guilty verdicts on indictments 1 and 3. He or she told me that the only charge on which the jury was deadlocked was indictment 2. Again, confirming things that we kind of already know. Breezy said it could have been because she dropped him off, potentially. But I mean, I thought there was, information that he didn't seem to be hit by a car based on all the medical evidence and reconstruction experts. But obviously the jury didn't agree. It wouldn't be the first time a jury hasn't agreed with me. Joanne, but this is putting this in the hands of Bev, right? Yes. Isn't she the reason for this confusion? Shouldn't they ask for a different judge now? So again, I've said this before. Some people agree, some people don't. Part of this has to be on the defendant, on the attorneys for not clarifying or changing the language. They agreed to the language that Bev read. So this is not going to be enough for a new judge, but at the end of the day, yes, it is in her hands. How does count 2 make any sense without count 3? To me, I kind of agree with you, but it seems like they were just thinking, this is the one that makes the most sense. Let's get rid of 1 and 3. But I agree. It's kind of weird that they were not guilty on 3, but almost guilty on 2. I think the ARCA being the third party thing fell flat for the jury. I think the jurors may want to know where they came from / who paid them for context. Kay, I agree with you. And it was a big deal to us because we knew who paid them, but that's not going to come in because that's not relevant. Who paid them is not relevant. It is relevant that the defense did not pay them. So there's no bias there. They're supposed to be independent third party witnesses. So that's what's relevant. The fact that the FBI hired them is not relevant and could be very prejudicial to say, but I get obviously your point. Logically speaking and common sense speaking, I get where you're coming from. Alicia Joe, it would seem horribly unfair if they retried and was found guilty. Where does she stand then? I agree. That's the double jeopardy argument. That's why in the interest of justice, counts 1 and 3 should be gone. They should go away. All right, let's keep reading this affidavit. On July 31st, I received an unsolicited phone call Hold on. Oh, this is just a repeat of 2, 3, and 4. Oh. All right, I think I'm on paragraph 4. Juror B told me that he or she was unfamiliar with the affidavit. Was familiar with the affidavit that I previously filed in support of this motion. Juror B confirmed for me that the screenshot of a text message exchange that I referenced in paragraph 4 of the affidavit was accurate. So that's big. This is building on credibility for this defense team. This is really important for them because they could be lying, or, these accusations that they could be lying, paying jurors off, jurors changing their stories, whatever. Well, the consultant or the intermediary for this juror, turns out everything they said was right. Text message they provided was right. They didn't provide clarification for the obvious typo in the text message, which this person does now, but it's confirming everything and building credibility on what the defense has. Specifically, juror B confirmed that he or she had texted it was not guilty on second degree and split in half for the second charge, which again is not the same as 9-3. So maybe there's going to be some differentiation there. When the judge sent us back with the Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms and we left. Juror B believes that every member of the jury, if asked, will confirm. However, she meant to write, this is the clarification on this page at the bottom of paragraph 4. Sorry, this is confusing how this was cut up. No one thought she hit him on purpose or even knew that she had hit him. Juror B believes that every member of the jury, if asked, will confirm that the jury reached not guilty verdicts on indictments 1 and 3. Juror B believes that even jurors who were leaning towards a conviction on some part of the indictment will confirm that the other 2 indictments were acquittals. He or she believes that the other jurors have been reluctant to come forward because there is so much public and media attention focused on this case. So will that last part cut against juror interviews? Will that last part cut against the defense? Hopefully not. Hopefully the jurors do the right thing. I know it's easier for me to say than to do. But I mean, if that's what happened, we can't. I mean, I hope they would not want to take a second chance of somebody being convicted and put in prison for a very, very long time on something you already acquitted them on. That would be horrible. I think they took the modified instruction for count 2 as applying to all counts. That's why they didn't sign the slips on 1 and 3 after. And I think that's possible because it had the lesser includeds, right? And again, it is confusing and these jurors have never done it before. So I don't really blame them. Mary Ellen, can you go over the wording of count 2? I don't have it memorized and I don't have it in front of me. But I've done it multiple times. If you want to go back to the stream where they were deliberating and we did that stream, like Verdict Watch or something, I went through it in detail. And it'd be interesting to kind of hear what I say at the time. Pita, I changed my YouTube name, formerly Breezy12. Now it's Boston Breezy RN. Clarifying, as I see a new Breezy in the chat, could the FBI come in if they wrap their case up? Did you see P.O. sent drunk messages to Turtle Boy? P.O. Paul O'Keefe, maybe? No, I did not see that. Yes, the FBI can do whatever the FBI is going to do. None of what's happening now is going to change that. Now, what they do and what the outcome is could be a spectrum of things. It could affect the trial. It could not. It could end the trial. It could just add witnesses. It could remove witnesses. It could change all sorts of things. It could have witnesses that are good for the Commonwealth. There could be witnesses that are good for the defense. Greg, what is the process if Bev denies the motion to dismiss? They appeal, but where does it go? Court of Appeals? Yes. So they'll go up the chain, Court of Appeals, and they can appeal this. But also the trial is coming in January. And they could delay the trial. They could stay the case. There's all sorts of things that can happen now if Bev denies this. Something Yanetti on the 29th because Proctor called here saying they were going to charge her. Called her saying they were going to charge her. Oh, you're talking about Karen Reed. Sorry. I think this was... Oh, July 31st. Sorry, I thought you were talking about July 29th. Okay. So that's why she hired Yanetti. Yeah. I knew all that happened. I didn't realize it was Yanetti from the jump, though. I just didn't know that. Obviously, it wasn't Alan Jackson, I don't think. Welcome to all the new members. This month's members only live is going to be our fantasy football league draft for Lawyer No members. So check out the community page for more of that. K-Rab, EDB recently did a stream on CoffeeZilla Logan Paul, pretty involved. Best place to start is CoffeeZilla's videos on Logan Paul's crypto zoo scam. Sounds like a lot. Sounds like something that may be over my head, but I will check it out if enough of you guys are interested in it, as we always do with any content on this channel. You guys pick it. Bev already said she was going to deny. Not quite. Maybe she gave us that lean, but not quite. Can Bev have the Commonwealth defense and jurors come into her chambers one at a time to answer predetermined questions? Yes. So I think there is a way that she can structure it like that. Will she? I don't know. She doesn't have to, but I think this is one of the options in the interest of justice and the interest of anonymity for these jurors that would accomplish the goal. So I do. Now, will one side object to that? I don't know. Did the Sarah Boone hearing get canceled? The weather is horrible, and I know Orlando's getting it as well. I think I saw something on the docket that said it got pushed to the 7th. Did you see that too? Okay, I think it got pushed to the 7th. I'm not sure. As soon as this happens, we will absolutely be recapping it and reacting to it. It'll be very interesting to see her representing herself in court. And I think she should get standby counsel. I don't know if the judge is going to agree, but I kind of think she should. Can the Commonwealth be prosecuted for jury intimidation with Lally telling the jurors they wouldn't be able to keep their names private? No. See, it doesn't go to this level. We have to be careful how far we take. It's at most a wink, wink. He didn't tell them he's going to let their names out. He just said, I can't promise you anonymity, which frankly, nobody can promise anybody anonymity fully, right? We don't know what's going to happen. People get found in the witness protection program. So you don't want to promise something you're not sure you can deliver on. And if you're not forced to, and you think it's going to serve your purpose, then maybe you do it that way. I would hope not, but let me see if there's any other questions here. I got about 5 more minutes. If you have questions, get them in. Why is it taking so long for Bev to make a call on this? I feel like we've been talking about this forever. Well, I got to be honest. Every supplemental motion that's filed, every motion that's filed by each side is more time for her to analyze, more time for her to read. So hopefully soon, but who the heck knows? Potentially dumb question. We see the juror came forward to the attorneys. Can they tell Bev straight about these? And does it compel Bev to do something? Like, can the jurors reach out to Bev? I guess they probably could. Florida judges, their emails are public. Their JA emails are public, and they can be reached out to by jurors. So the jurors could reach out to. Somebody told me that's a lawyer from there. Don't call her Bev. She's a female judge, and that happens to female judges so much more than male judges. So I'm gonna try to correct that. Although it's hard for me because whenever I think of her, first thing that pops in my head is Bev. So Judge Canoni. I also never say words I can't pronounce, and I don't know if it's canon or Canoni. So I'm just gonna go with Canoni, Judge Canoni, and I'm mispronouncing her last name. Hopefully that's less disrespectful than calling her Bev. She is a judge. I try to respect her as much as I can. So Judge Canoni. Yes, they can call her, they can email her, they can tell her directly. To me, this is kind of like mandatory reporting. If a juror is telling you this, how you could overlook it or bury it to me is like, why are you a lawyer? Why are you a judge? Why are you a cop? Why are you doing this stuff? If the jury's acquitted them and we can find out if they really acquitted them, let's just do that. Like, come on, what are we doing? Especially if you can do it and split the baby, which judges love to do. You're not throwing the case out altogether. They still have count 2. They can still go forward. They still may convict her. She still may go to jail for a long time. You can still sentence her to the max if you think that's what you deserve, what she deserves as the judge. Could they do like they did in Murdaugh with questions the jurors off camera and individually? Yes. They can do it like Murdaugh. They can do it like they did on Maya's case, or they could do it back in chambers in complete private. Can you do it like Michael? Do it like Prince? That's what it reminded me of. It's like, yeah, you can do it all. There's all sorts of ways to do this, to protect anonymity, to get justice, to get information, to do this right. We're in a system, and the beautiful part about the system is it's not as rigid as it may seem. The law leaves openings for us to do things in the interest of justice. And this is one of those things. Do we want to invade the province of the jury? No. Do we want to force the jurors to come back and testify? No. Do we want any public backlash on the jurors? No, absolutely not. But these are open and public jury trials. So if we're going to keep that system, this is always something that could happen. We have to have just results. We have to. We can't just overlook them. We can't just throw them away. David said I'm pronouncing your name correctly. Thank you, David. It will make my brain fart less, hopefully. Did you review the Delphi pretrial hearing on confession? So no, I didn't. There is a ton of stuff going on in Delphi. if and when that case goes to trial, I'm going to jump back in. I do not have the capacity right now to pick up and figure out everything that went on in that case. If you guys want me to cover something specifically, let me know in the chat. And if enough of you have a specific document or hearing you want me to break down, I will. But I know how you guys are, okay? And you guys, it's a blessing and a curse. You guys know these cases inside and out. So I'm not going to halfway look into something and not know the answers and not know what we're talking about, okay? Because you guys will call me on it. You guys will know. I want to be up to date as much as I can so that it's fair to you guys, so you know what I know, and you can take it with either my full force and effect or a grain of salt, okay? And I like to do that so we can all be on the same page about what type of content and information I'm providing. Julie, I think it would be useful for you to explain how Alan Jackson got on the case in that state. Another out-of-state lawyer is also trying to get Massachusetts status. So it's very easy. You can pro hoc vice, it's called. Basically, you sign in if you're a member of the bar in good standing in another state, and you have a lawyer in that state who's also in good standing, sponsor you or sign off that you know what you're doing, you're competent, you can come in and handle this. You pay a fee, boom, bada bang, you're trying the case now. Or I guess I should say bang, bang, you're trying the case now. Will you cover the Long Island SK? Yes. If and when that goes to trial, we've done some already. We have a playlist on our list. But again, if you guys see a case you're interested in pop up on any of these comments here, go ahead and let me know in the comments that you're also interested in. You know, whatever gets the most interest, I'll do. Obviously, I can't do every single case that's out there, but the ones that has the most interest from you all, that's what I pick. Lawyer's daughter. Heard they were hung on misinterpretation morals clause. Karen Reed actions set events in motion that led to OJO's death, left him intoxicated in bad weather. I don't know. I don't know how we would find that out unless the jury told us. So it's hard for me to kind of jump there or really analyze that much. Honestly, this is probably something we can't get into with the jury. If they would have convicted and they would have thought this even incorrectly, I don't know how much we'd really be able to get into it. And would we have consensus on that? Yeah, Corey Richens is another one that we're looking into for sure. Make sure you guys all hit the like button, please, if you have not already. And make sure you subscribe and hit the reminder bell so that whatever content you want to see and that you're voting for in the chat, that you get alerted whenever we do a video. Yeah, Treviso's coming up. I would be surprised if it went to trial on that trial date. Now, Adelson one I do want to cover as well. That one I think actually could go to trial. Cannoni is Italian. Like Greek, it's pronounced like it's spelled. Cannoni, Judge Cannoni. All right. No, it will not be the same jury. They will pick a completely different jury for the new trial. All right. That's all we got, folks. I appreciate you joining. Thank you for all your questions. Thank you for all your comments. You guys are the best. Continue to let me know what it is you want to hear, see, and talk about. Make sure you hit the like button on the way out. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.